Welcome to Beyond Borders, the Immigration Evaluation Podcast. Whether you're just starting to explore how to add immigration evaluations to your practice, or you've been conducting evaluations for years, this is the place for you. I'm Dr. Maria Lurye, and I can't wait to share today's episode with you.
In late May, USCIS issued a policy memo that doesn't change the law itself, but changes how officers apply it. It reframes the green card process for people already living here, what's called adjustment of status, as an extraordinary favor rather than something that you're entitled to once you qualify. So in plain terms, being eligible is no longer enough. Officers are now told they can deny otherwise qualified applicants by weighing the whole picture, and people who could instead apply from their home country may be expected to do exactly that. So if you've been trying to make sense of this immigration policy lately, or reading announcements, getting questions, to help us think it through, I've invited someone who has seen these decisions from the inside. My guest today is the Honorable Maria Lurye. Maria served as an immigration judge in New York from 2017 until the end of 2025. Hearing and deciding exactly these kinds of cases. Before she took the bench, she spent nearly a decade as an assistant chief counsel with ICE, litigating removal cases and writing appellate briefs. She is a member of the Roundtable of Former Immigration Judges, and she now runs her own firm, where she helps attorneys with case strategy, removal defense, and the immigration consequences of criminal charges. So I came across her writing on this recent change, and the way she broke down something that was genuinely complicated is what made me want to bring that clarity to all of you. Now, one quick note before we start. As you know, I'm a psychologist, I'm not an attorney, and most of you listening are mental health professionals. So I'm going to lean on Maria to help explain things in plain terms. Welcome to Beyond Borders.
Thank you so much.
Of course. So before we get into this specific change, I want to start somewhere simple. When the government issues one of these policy memos, what is that exactly? And how is it different from a law passed by Congress? And how much weight does it actually carry for the officers making these decisions?
So laws are made by Congress, like you said, and they're binding on everyone. But a policy memo is more, I would say, like internal guidance that's put out by the agency on how they expect their officers to apply that existing law. And while officers are expected to follow the policy memo, that's part of their job, that memo can't override the actual statute or regulation or even controlling case precedent. So what I would say in this context, while this memo might be changing the way officers might approach or what what kind of factors they might consider, it doesn't actually change the underlying laws.
Got it. Okay. So with that foundation, let's talk about this particular memo. So
Okay.
in plain terms, what does it say, and what is it asking officers to do differently than before?
Okay. Well, historically, although adjustment was always discretionary, officers were generally guided to approve cases where there was an absence of negative discretionary factors and the person was otherwise eligible for adjustment of status. And in fact, we have longstanding case law about this, a case called Matter of Awry. It specifically said that absent adverse factors, adjustment will ordinarily be granted in the exercise of discretion. But the big change is that under this policy, it isn't enough for someone to show that they qualify for adjustment of status and haven't done anything wrong. Now they have to show that there are these extraordinary or compelling reasons that USCIS actually should approve the case. And they may view certain immigration violations or other conduct as reasons to actually deny it that haven't historically been considered. So, for example, they really go and identify 4 negative factors, some of which are not such departures, but some of which are. So the first of these which is the real change in perspective, is that they are treating the fact that the person is applying for a green card in the US rather than outside the US as a negative factor in itself. And that's a major shift. Um, Another
Let's
negative
pause right
factor.
there.
Oh,
Let's
sure.
pause right there for a second for people who don't understand what the difference is. Can we just briefly explain? Some cases are adjudicated here within the US, and that's called adjustment of status, right?
Yes.
And that is done at a USCIS office. And then some cases are decided abroad in the US embassy or consulate of the applicant's country of citizenship, correct? And
Right.
that's called consular processing. But technically, it's pretty much the same type of interview. It's just called differently because of where it's located, or is there
Right.
more differences?
Right. It's because, when you're consular processing, the consulate is adjudicating your application. And when you are um, adjusting your status, USCIS or the court are adjusting your status, but both are pathways to a green card.
Right. Except here, when you do it here, you can have your attorney with you,
Right.
correct? And
Right.
but when no, I don't think any attorneys are going to travel abroad to accompany somebody to a consular processing interview.
You would
In
be
a,
surprised. You would be
oh, is that
surprised. There
right?
are some attorneys that will go with you to a consular processing. I think the problem is that in some consulates they don't let attorneys in, right? Just as
Ah,
a matter of security. In some of them they do, but they will support you or let you wait in the waiting room sometimes. So that is a big difference. And then there are some minor legal differences, but overall, it's just about the same process.
right. But it's a really big deal because it's not the same taking a day off to go to this interview across town than traveling abroad and staying there and that's the other thing, right? I mean, it's not like this is your interview, you go in and then you come back tomorrow. It's
Right, right. Yeah, I mean, there's a huge cost associated with it. You have to take time off of work. You have to leave your family sometimes. You're going there for quite a substantial amount of time. Sometimes there are some ways when you can try and time it so that if you know your interview date already, maybe you can leave a little bit later and come back fairly quickly after that. But for some people, if they leave, they have bars to re-entering for several years. So it could be a really lengthy process if they have to consular process.
right. But I'm getting ahead of myself, but anyway, would the provisional waiver help in those cases, trying to avoid that 10-year bar?
Definitely, the provisional waiver can help, but again, it's discretionary. So uh, it's still up to whatever officer you get, whether they
Right.
will allow you to have that privilege.
Right, right. Because if they say no, or if they say, we're going to put this on hold, we need more evidence or anything like that, the person's stuck abroad until
Right, right.
they get the green light.
Well, I think the provisional waiver they would get ahead of time, right? Because so they'd be waiting for that. But there are other kind of waivers. For example, if they didn't get the provisional waiver, they can still apply for a waiver, but they would have to apply for it in their home country, and then they would be waiting over there
Like years sometimes.
years. Yeah,
Hmm.
yeah.
Hmm. Hmm. So I interrupted you. You were going on talking about the adverse factors.
Yeah, so another adverse factor is that they are emphasizing is whether the applicant stayed in the US for a time longer than they were allowed or if they were admitted for a certain purpose. If they stayed beyond that purpose. So for example, say somebody came in on a student visa, but they stopped going to school and they stayed in the country. That would be staying beyond your purpose. And then likewise, obviously, they are looking to see if the uh, person behaved in a way that's contrary to the reason that they were actually admitted. So if you came as a tourist, but then you start working, right? You're no longer a tourist anymore. So that's
Right.
you coming for a different purpose and doing different things than you were allowed to do under your visa. And then they want to know about any other kind of immigration violation. Did you have a prior order of removal? Did you make false statements to the government? Is there anything else? Are you a repeat offender? Have you kept coming illegally many times? Those kinds of things. That was always considered, obviously, but it's really the first three factors that I talked about, which were really a little bit more scrutinized than they have been before.
Right. And a lot of people that I've talked to expect this to get pushed back in court. What would be the basis for that, and what would a challenge actually look like?
I think at this point it's a little early to tell, but depending on how the memo is actually applied in practice, there could be some arguments that this is such a departure from decades of practice that maybe somebody would find it to be arbitrary. Or they could say that it exceeds the statutory authority of USCIS. For example, I told you about that case matter of RI, and that's still good case law. So someone could argue that the memo is in conflict with that case, and so it shouldn't be allowed to stand.
Okay. Okay. And where do things stand right now while this is all kind of unsettled? What does it mean for people who already have cases in progress? And what are you telling petitioners to do in the meantime?
It's definitely tricky. It's definitely a confusing time. I I think the best course of action is to just be prepared, right? We've gotten some clues. What are they looking for? They want to know why why did you decide to stay here? Why didn't you go back to your country and consular process there? So be prepared to have those answers, right? Why did you start working? Was there some emergency? Did you fall ill? Was there a reason that you didn't just go back to your house after your country after your visa left? Have those answers ahead of time. And then also, on the positive side, they also have to consider all the positive parts of your equities, right? Did you build a family here? Do you have ties to your community? Are you um, helping the economy by building a business? Did you serve in our military? These are all positive things that we also have to include and be prepared to put forth to the officers. So that's the main thing that I've been advising. And then if you can help it, maybe give it a month. And you know what I mean? If you're not in a rush to adjust your status exactly today, maybe wait it out a little bit and see how this plays out. Now, that's not advice I can give everyone. And obviously, every case is different and has its own, for example, if you're already in court and somebody's about to deport you, obviously don't wait to file your application, right? But, you know, if nobody's looking for you, let's call it like that, and you've waited this long, I'm not saying to wait forever. Don't wait 15 years. But maybe let's see what happens next week, for example. This memo only came out recently, right?
Yeah.
So
Yeah.
so maybe in a month we'll already kind of know where are people going with the litigation that you were
Mhm.
talking about before. Or
Mhm.
maybe this really doesn't change anything. And if you had a strong case, you still have a strong case and everything will go forward. The problem is it's just too early to know. So
Right.
you know,
I
my golden rule is just before you do anything, make any decisions, take a deep breath. Step away from it
yes.
for a moment.
Yes.
Think about things, right? I mean, as a psychologist, I'm sure you probably give the same advice. And lawyers, I'm going to tell you a secret. Half of us, probably uh, should have gone to become psychologists instead. It's a lot of hand holding, a lot of counseling of people who are in really stressful situations, and that's my number one advice. Don't panic.
Yeah.
Take a deep breath. There's always a way out of something. There's always a solution. You're gonna be okay.
Yeah. Yeah. That's great advice. That's really very supportive advice. And true. And true.
Yeah.
Um, the memo leans on this idea of adjustment as something extraordinary. Can you explain what they mean by that?
You know, I can't because it's very confusing. And I have to tell you that
Right.
the memo, they use this word, but I think it's more it's less of a statutory standard and more of, let me say it's like rhetoric, right?
I
It's
see.
using this word to imply that adjustment of status shouldn't be treated as something that's routine, right? When historically it always has been routine. And so, but what it doesn't do is it doesn't actually define this word for us, and it doesn't tell us what would rise to that level of being extraordinary. But, um, so again, I think it's a bit early to tell, how they're really going to apply it and what they're doing. And I think I happen to be in a chat with many lawyers, and I have a lot of clients who, I do consulting for other lawyers. So I ask them frequently what's going on. So people are talking to each other and connecting and trying to gather that information. But, again, some clues we got from the memo is that they're looking for us to give some justifications for why they should disregard those negative factors that we talked about. And for example, when we're addressing why a person sought adjustment of status rather than consular processing, I think a psychological evaluation would be helpful where there is trauma present, and that evaluation can give us some context about that person's actual ability or willingness to leave the United States.
Right, right. And so in our waiver work, the standard that we live with is extreme hardship, right?
Sure.
Or for waivers. Are those would you say that those are sort of related ideas, or are they totally different?
I think that USCIS is not entirely, setting out its guidelines in writing yet, right? They've used this word extraordinary, but extreme hardship, even even that term is a little nebulous. It's hard to define sometimes, right?
Oh yeah.
But there is a lot of legal law cases surrounding it. So we can kind of look to those other cases which set the precedent, and that's how we know what that standard is, right? However, as I said, right now it's just so early in the process. We don't have those examples yet of what it really means to be extraordinary. So, could they be related? Could they be the same standard? Possibly, possibly. But I think we really have to think of it differently, because I think when they're using the word extraordinary, they're really using it as a justification tool, as a justification to say this isn't, you know, don't think that adjustment of status is just a normal thing that we grant to everyone. It's an extraordinary thing. That's what they're trying to say. It's not really a set standard the way extreme hardship has been litigated or defined throughout the time.
Mhm, mhm, mhm. So this is the part that my listeners will probably be waiting for. So
Sure.
in these cases, are there points where you mentioned one already, but like, are there points where a psychological evaluation could genuinely be useful, or is this totally different?
Well, definitely it could be useful. I think I think that if I'm going to frame it in a way that might be most useful for your practitioners, is if you're going to do those types of evaluations for these cases, think about three key questions, right? One is, what would the impact of a denial or having to separate have on the applicant and their family members, right? The second is, what helps to explain any of these adverse factors, right? Um, the ones that we talked about, and I've given you a couple examples of that. And then the third question is, what is the nature of the applicant's family relationship and the role with that family and that community? Because, like I told you before, we have to think about the positive equities too, right? And so when we're thinking about those positive equities, USCIS actually has a memo separate, a policy memo separate and apart from this one, where they talk actually about other factors that they consider. And one of those factors is family and community ties. And they specifically write there, like, fa- I'm reading from this
Yeah.
chart that I see, right? They're
Uh-huh.
saying family ties to the US and the closeness of those underlying relationships. That's a positive factor. hardship to the applicant or close relatives of the adjustment application if it's denied, length of lawful residence in the U.S., status held and conduct during that resident, particularly if the applicant began his or her residency at a young age, right? And then on the negative side, in that same chart, they talk about the absence of close family, community, and residence, right? So
Interesting.
if we're trying to overcome other negative things, the only way to do it, it's basic math, for every minus, we need a plus, right? And hopefully more pluses than minuses. So we want to talk about those family ties. And then, also, it's kind of important for our society at large to have people who have good employment skills, who have good business skills, right? If somebody is here and they have a thriving business that's supporting other American individuals, giving them jobs, they have education, they have some specialized skill that another person doesn't have. We want to include that. We want to make sure people are aware of that and know about that. Obviously, your reports might not be the only evidence of it, but it's always good to bolster what you have, right?
Right.
And,
Right.
On the other hand, the negatives of that would be like if someone is chronically underemployed, if someone is chronically, getting fired, well, what's the reason for that? What's happening there? But at the same time, maybe you could give a context for that, right? So you also have to keep in close contact with the attorney and just make sure that you know the scope of what kind
Right.
of information they're looking for. Obviously you have to do everything within your ethical boundaries, right? You can't just take
Well,
out
and within our right,
you
and
know,
within our scope. So, and what
yeah,
we could comment on, right? So, as mental
sure,
health professionals, we're mainly, um, you know, our our main focus would be on their mental health, their personality characteristics, the quality of their
sure,
relationships, their vulnerabilities that sort of predispose them to a psychological harm, right, or to
yeah,
compensation. So,
yeah,
but so if an evaluation does have a place here, it seems again, going back to like say provisional waivers, which are, I think, what would be the most similar to this type of case, we're evaluating a qualifying relative. In these cases, it sounds like we could be evaluating either. We could be evaluating the applicant or their family member. And does the qualifying relative term even apply? Is that waiver language that doesn't really map onto this?
I mean, technically that's waiver language, right? But it doesn't mean that it's not applicable. In the sense that it really could be anybody. It could be the applicant themselves. It could be their family members. Because as I told you when I was reading uh, the policy guide earlier today, they specifically list hardship to the applicant or close relatives if the adjustment application is denied, right? So USCIS themselves is telling us we can consider that's one factor. And, the standard that we're looking at is the totality of the circumstances. So
Right. So it's
we're
still
looking at
that.
everything. Yeah, it's
Is
still
it?
that. So,
Is it?
um, so I think it's really dependent on what your client asks for, right?
Sure.
Uh, and I think it could be multiple evaluations. It doesn't just have to be one or the other.
Mhm. Right, right. And thankfully, close relative might, in these cases, include children, which in
Right, right,
provisional waivers, it doesn't. So,
right, right.
mhm.
I want to take a quick break to share a few ways that you can go deeper in this work. If you're looking for personalized support, I offer one-on-one consultations where we get into the specifics of your cases, your reports, and your growth as an evaluator. I also host a monthly consultation group on Zoom, the first Wednesday of every month at noon Pacific time. It's open to all experience levels, and it's a great space to bring cases, ask questions, and learn alongside others doing this work. And if you're looking to grow your practice, my online directory connects trained, qualified evaluators with attorneys and individuals who are actively looking for referrals. You can find links to all of these resources at psychevalcoach.com/podcast. Now let's get back to the episode.
So let's step back from this memo for a minute. And so since I have you here, so thinking about immigration evaluations generally,
Okay.
when does this kind of evidence really help an adjudicator and when does it miss the mark?
Well, I would say that when a report is personalized and relevant, it's where it's most useful, right? When I was a judge, I can't tell you how many reports I got that read like they were written for a lawsuit. And I can tell you that some telltale signs would be if you had very formulistic boilerplate that was just repeated from case to case, where you had conclusory legal findings, right? Like the person would say, in my opinion, this person would suffer extreme and exceptional unusual hardship. That's a very, specific legal finding. And we're
Yep.
relying on you as experts in psychology. We know the law, we don't know psychology. So, that's challenging for us, right? Then we know it was written specifically for that purpose. Or we think we know. Um, and also that statement alone wouldn't tell us your analysis. How did you come to that conclusion, right? So uh, I think something more beneficial would be something that gives an actual diagnosis if a person, what is this person actually suffering from? Some clear prognostic statements, because a lot of times, for example, in the cancellation context, it's not enough for us to know this person has X disease. We also have to know how does disease get treated, and if that treatment then is available if they have to go back to that other country, or how this treatment could affect their ability to relocate or their ability to study, for example. For example, if a person, let's say a student has ADHD and they're taking, I don't know what you take for ADHD, Ritalin, right? If you're
Ritalin.
taking some medication, stimulant medication, and that enables you to pay attention in class, to study, to be a good student. But in this other country, that medication isn't available to you. What would the effects be if you didn't have that medication, right? We're not asking you to tell us, is that medication available or not available? We're asking you to tell us, we're not medical professionals. Maybe it doesn't matter if he takes it or doesn't take it. We don't know. But you, as a professional person in that field, you can guide us. You can tell us, you know what, actually, it would be a hardship because the person's focus would be limited. The person wouldn't be able to sit still. The person would, likely fall behind in school, whatever the symptoms might be. I'm not sure.
Right.
Um,
Right.
so
Right.
that would be, and something overall showing some real relationship with this client, especially if there was like a pattern of consistent course of treatment, even if it wasn't with you. I understand maybe as a forensic psychologist, like you might only be meeting this person once, right? But
Yes.
but is this the only time they've ever gone to get some kind of therapy? Is there a reason that that didn't happen before, right? Like maybe they didn't have the money for it and you can explain that. Or
That's right.
they don't have health insurance, they don't know how the system works, whatever it is.
That's right.
Or conversely, this person always goes to see a therapist and we've reviewed their records and
That's
they,
right.
based on the records we reviewed, they have this substantial issue, whatever your report goes on to say, right? But I think not every adjudicator is aware of the fact that certain psychologists, they may only meet the person once, right?
Yeah.
I think some adjudicators
Yeah.
will look at something and say, oh, you only met with them once.
You paid them to write
You
this,
paid them to write
basically.
this, right? So
Mhm.
you also have to, include a little bit of information about your own specialty. Let's call it like
Is
that.
it? Is
You
it?
know?
Right. Like we include a footnote explaining why we're only meeting with this person only once, what our ethical guidelines are, and how that would constitute a dual relationship if we
That's
were
excellent.
evaluating our own patients,
Right.
and how we're trained to do this. This is what we
Right.
do. If I go to a detention center, I usually just go once and just do the evaluation and leave.
Right.
And I'm talking about for other criminal defense work. And nobody ever questions that. But in the immigration field, for some reason, we get a lot of pushback.
Yeah, you know what I think it is? Uh, I think what it is that we see so many people just going once, and we wonder to ourselves, well, did they just make this for this purpose, just to say, oh, you know, we never really cared about this. This isn't really going to affect us, but now that it might affect our immigration case, maybe we should say something about it, right? It
Right.
doesn't mean it's untrue. It doesn't mean there's fraud, but just even, or sometimes it does, but
Mhm.
but even even so, if it's not a big enough deal for you to go and get the treatment, or it's not affecting your life this significantly, it's not going to affect it that significant. It's not going to be that big of a deal when you change your life too, right?
I mean, and to be
Maybe. I
honest,
mean,
I am asked to speak to the legal field a lot, and it's usually on the topic of self-care. And attorneys need therapy. Are they
I,
getting it? No. So does that mean that you don't need it because you're not getting it?
no, no.
Let's bring it home. Everybody can relate to that, right?
Are you trying
So
to
it's
tell me
just,
something?
but right, but if you're going to hold somebody else to that standard to say like, well, you're saying you're depressed, but you're not in therapy, so you must not be depressed. It's like, well, let's look within too. How many of your peers are anxious, depressed, stressed out, and not seeking therapy? And does
Sure.
that mean that it's not severe enough? No, it means there's other reasons why they're not doing it. And when you're talking about, working with immigrants, culture plays a huge factor. I don't like to place like blanket statements that, oh, well, Latinos don't like therapy. I'm like, I'm a
Sure.
Latina and I'm a psychoanalyst. So therapy like runs in my blood. So that I wouldn't fit back. But so I think it's more nuanced than that, than just plain
Yeah.
blanket statements. But it is certainly important and significant because it's true. It's what we see day in and day out.
Well, I think that's why it's so important for you to include that information about your work itself, and to also teach the attorneys who are presenting it to do that, because I have, you know, I have seen a lot of evaluations in my day, and very few of them include that information. It
Mm.
happens to be that I'm interested in the subject, so I sort of studied it myself a little bit. Um, but not everyone has the time to do that. Not everyone has the desire to do that. So when your attorneys are making their closing arguments, or if the DHS is raising those arguments in court or at the USCIS interview, you want to make sure your attorneys know that so that they can defend your credibility also.
Right, right, right. And so kind of along those lines, like for any mental health professionals preparing one of these evaluations, what do you wish more of them understood about how their report is actually read and used once it leaves their hands?
So I would say the number one thing is nobody has any time. Okay. Some USCIS officers, judges, I'm going to tell you a secret. Sometimes we're just opening that file for the first time and scanning it, right? Sometimes we're reading it
Get to the
after the
summary.
fact.
Is
We're
it?
getting to the summary. We might have 10, 15 minutes before a hearing to really look through it. Don't give all my secrets away. I know I'm on a podcast, but I prepared and read everything thoroughly as a judge, really, genuinely. Um, no, but in all
You seem like you
seriousness,
would.
we 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 will do that, but sometimes we can't do it right away, or we can't do it, it just we don't we
Well,
do
let
it,
me
but we
put it this way. Would you give more weight to a 25-page report than to an 8-page report?
no, no. I mean, the number of pages doesn't matter. It's the content that matters. And that's really important. Sometimes I got the feeling that people were being paid by the page, right? So, and the
Some
truth
are.
is, it's,
Mhm.
well, maybe some are, but
Well, report writing agencies do, sometimes
yeah,
charge by the page.
yeah,
And those are
yeah,
the agencies that I've come across, and they're like, we write 25-page reports. We
yeah,
include
yeah.
country conditions. We include
Sure.
references. And I'm like, oh my God.
Okay. All right. Well, hopefully they've included why those analysts are also country conditions experts, but that's a different story. Um, but I would say, you know, maybe keep it simple, stupid, as they say, write it in very simple, plain language, because the people reading it, I mean, as smart as they are, they're not psychologists. They haven't studied this field. They don't know all the terminology. So, say it as if you were saying it to a third grader, in plain English, and you know, write clearly, concisely, and I would say, okay, include 25 pages if you want, but put the most important stuff on the first three, or, whatever it is. Lead with your best stuff first, because we might not get through all of it. We might skim it. A summary is always great. It's just so we can kind of know what we're looking for. Um, and then it's also really important to know that anything that you give to the government is going to be scrutinized for credibility. So I would say only include what is relevant and appropriate in each case. And if you're able to speak with the attorney about what the scope of the assignment should be, or with the client themselves, but sometimes the attorney has a little bit more training and can know what to look for, right? That would be really important because, like I said in that example, of the person with the multiple arrests, right? Like, you know, some people might look at that and think that's terrible. Some people might look at that and think that's a very sympathetic situation. And, depending on what this is being submitted for, maybe that information doesn't have to be identified in this particular report. I'm never saying hide arrests or any kind of uh, inappropriate behavior. I'm just saying, there are other ways to overcome that, and maybe this isn't the right forum for that. I don't know. Each case is separate. Obviously, I'm not advocating for any kind of fraud or misrepresentation or
Of course.
non-disclosure.
Mhm.
I just, and also I don't know what your ethical obligations are as a psychologist, right? Maybe there's something that you're required to put into these reports. Don't also let anybody dictate, you know, or push you beyond your own ethics, right? That's
Yes.
also very important because,
Yes.
that's your reputation on the line,
Mm,
and your
absolutely.
credibility has a direct bearing on the credibility of the respondent, of the applicant, and it,
Absolutely.
you know, and
Absolutely.
every other person that comes later. Because believe me, when I used to work for DHS too, we take notes and we put
Mhm.
it, when we have an
Mhm.
expert, we write down what they say to us. If we have that expert again, I'm pulling out that file on Mariella and saying, oh, you
Mhm.
know what? She told me this last time. Let me see if she says the same thing this time, right?
That's right. That's right. Yeah. Yeah. Well, this has been wonderful. Thank you so
Oh,
much.
great.
And thank you for the short
Yeah.
notice. I know people were just, asking me questions like, what's going on with this new memo? Are we going to stop seeing evaluations? What's happening? And attorneys are freaking out. And I saw your post on LinkedIn and I said, she knows what she's talking.
Well, thank you. I'm glad you think so. But
And
I
that you care, that you're passionate, because nobody is asking you to do that, nobody's paying you to do that,
yeah.
and so that
Well,
just shows
thank you.
how passionate you are about what you do, and that's
And thank
very
you for
meaningful.
the work that you're doing. And it's such a pleasure to be here with you. And I know that it's a little bit cliche to say, but also take care of yourself because
Oh
these are
yes,
very trying times and,
these are.
secondhand trauma. I know for myself, it's real.
Yeah,
And,
I know. I know.
the best thing about being in immigration is actually getting to have these relationships with our peers, even in different contexts. And thank you so much for including me. I'm
Yeah,
genuinely honored.
of course, and I look forward to meeting you in person in a couple weeks at Ayla, right?
Yeah. Yes. Yes. I'll see you there.
Okay. That was the Honorable Maria Lurye, and I am so grateful that she made the time to speak with me. Maria gave us a framework for these evaluations, 3 questions to anchor on. 1, what a denial or a separation would do to the applicant and their family. 2, what helps explain the harder facts in someone's history. And 3, what this person's role is in their family and their community. So much now turns on the positive equities, the pluses that we set against the minuses. And on the question that I've been sitting with is, whether qualifying relative even applies here. She was clear that is waiver language, but in these cases, the person we evaluate could be the applicant, could be a family member, or several of them. And unlike provisional waivers, close relatives can include children. She also gave us a masterclass in how our reports can actually get read. So write for someone who has 15 minutes and is not a psychologist. Lead with your strongest material. Skip the boilerplate and the legal conclusions, because your diagnosis, your prognosis, and your reasoning are what they need from us. Explain why you only met the person once if needed. And guard your credibility, because as she said, they keep a file and your name is in it. So what I'll carry with me is what she said at the end about the secondhand trauma and taking care of ourselves. This work asks a lot of everyone on every side of the case. So take the breath that she talked about. Don't panic. There's almost always a way through. I'll see you next time.